So to let you know, Your Honor, I'll give you a few quick background facts. This building was built in 1966. It's got 29 stories on the high rise.
I drive by this place all the time, so I know where it is.
You can see where it is, Your Honor. There is the photograph of the roof that's in question. The red arrow is pointing generally to Mr. Jackson's unit. Mr. Jackson has his unit listed for sale, and this is on the internet about his 1,100 square foot unit. These are the, as Ms. LaBeouf pointed out, these are the governing documents. The building was converted to a condominiums in 1979. Your Honor, this is where the heart of this matter comes from, and that is that there's a reasonableness standard that imposed on the duties with respect to the obligations of an association to maintain the common elements. It's not just a strict liability. If something happens, that means somebody gets damages. There has to be some understanding that there's a reasonableness to what the board does and how it approaches its obligations for maintenance.
Why haven't they repaired his roof?
Well, Your Honor, we have. And despite the statements earlier, there has been no leaks in Mr. Jackson's unit from the roof since 2018. And I'll explain that as we go through, Your Honor.
Okay.
Now, there is a reasonableness standard, and it's set out in the Puser argument, the Puser state case that we've cited here. And there is considerable discretion in undertaking the duties to maintain. And in that case, there was an issue about maintaining the roof as well. And the court noted that there must be, when you're vesting the authority of the association to act through and through the board, it's got to have discretion in order to exert its managerial and administrative responsibilities. Now, everybody belongs to in the Preston Tower belongs to condominium association, and you give up certain rights as a condominium association. You give up some things that you dedicate, and you allow the board to act in your best interest, and that's been cited in the Puser case. So the reasonableness standard that was imposed by Puser and the other cases we cited has been codified, and I do not agree with Ms. LaBeouf's position that it's only relative. The 202.004A is relevant only to restricted covenants, and it was applied in the Hoyt case when that was also a maintenance standard that was at issue. So the idea, Your Honor, is to understand before I get to talk about these things is that there's got to be a reasonableness standard imposed on the association, because not everything can be done right away. Not everything can be done at the drop of a hat. If a roof needs to be replaced entirely, that's not done overnight. So there's got to be some sort of understanding that
I appreciate and I get the standard. I just want to hear how you guys have met it.
So, Your Honor, the first thing is that we did act reasonably. Let's talk about the fact that we have performed, and I'll take you through this. So this roof is pretty old, and in 2017, the association put in a complete roof coating. It had a 10-year warranty on it. There were also, we'll talk about this in a moment, there were also repairs made in 2018 based on the reported leaks, and that no leaks have been reported to Mr. Jackson's unit since 2018. So in 2017, Preston Tower approved a bid for urethane coating. It was applied by Brazos Urethane. It cost $85,000 to put on it. The roof is structurally sound. There's nothing wrong with the roof. This is the testimony of the engineers that have we proffered as their evidence. Let's talk about the leaks in 2018 and how the association responded. So in 2018, March 2nd of 2018, Mr. Jackson reports a leak in his bedroom, and this is the photograph of the leak. The general manager, Kinahan, immediately calls Brazos Urethane. They're the ones that installed the roof and said, hey, you got to look at this roof and figure out what's going on. And they made markings. Now, there wasn't a whole lot of weather data. Excuse me, the weather data reflects that there was a very extraordinary rainfall then during that period of time. Mr. Jackson then reports on August 17th a ceiling leak in his study. So the general manager, Kinahan, responds within 24 hours and told Mr. Jackson, and they looked at the area where Mr. Jackson's leak was. You can see a photograph of that leak. Kinahan immediately emails Mr. Fadig at Brazos Urethane requesting an inspection. Mr. Jackson informs Kinahan that he prefers to perform the repairs to his ceiling rather than having ICI or the association repair it. So fine. Mr. Kinahan says, all right, well, get your proposals for repair and submit those for the board for review and approval. In other words, the association is saying we'll pay for it. Brazos Urethane, and they inspect the roof. In August of that year, Brazos Urethane performs additional work on the roof, and including replacing rotten wood, installing new roofing materials, and applying of additional coating above Unit 2907. Then on August the 27th, Kinahan goes back to the manager of Brazos Urethane to address further concerns to inspect the roof. Again, the installer of the 10-year warranty covering. On September the 5th, Brazos Urethane submits the bid for additional work. On September the 6th, Mr. Jackson sends an email reporting a leak in his hallway going from the living room to the bedroom. And he says this is the third leak. Now, this particular leak, you have a photograph there, Your Honor. This is in the hallway, and this is an HVAC area. What you see here is a lowered ceiling. It is not a roof leak. It is a lowered ceiling. The HVAC units are actually just above the area of the ceiling that you're looking at. The ceilings in the other rooms are higher. They've got concrete. They're close to the top of the roof. So immediately when Mr. Jackson reports this particular leak, the HVAC leak, the maintenance is called, and it was determined that the condensate from the coil had backed up. In other words, something you see quite often where a pan overflows and it leaks onto whatever's below it. And on September the 7th, the day after Mr. Jackson reports it, they immediately go out and they take care of it. They clear the lines. And then on September 7th, Mr. Kinahan tells Mr. Jackson he will meet with Richard Wells. We saw earlier that Mr. Jackson wanted Mr. Wells of Eclat to review the roof, and he wanted specifically Mr. Wells, who happens to be an owner of units at Preston Tower. He also is a roofer, but he wanted Mr. Wells to look at it. So Mr. Kinahan said, sure, we'll go have somebody look at it. We'll go have Mr. Richard Wells of Eclat review the roof, determine what needs to be done. Then on September the 7th, again, Mr. Kinahan tells Jackson to obtain proposals for the ceiling stains from the HVAC to the hallway to submit to the board for review and approval. Again, Mr. Jackson wants to do this work, and we'll talk a little bit later about Mr. Jackson is ongoing. He has some ongoing remodeling to his unit concurrently with these things. So notably, there was a 12-inch leak in September, but again, no leak was reported. But immediately after he reports this, ICI jumps on it, clears out the pan, gets it done, and Mr. Jackson wants to do the repair himself. We say, fine, submit your work. Okay, in September of 2018, Preston Tower commissions and approves Eclat to repair certain portions of the roof, and specifically including areas over Unit 2907. In October, Mr. Jackson asked Mr. Wells to come up to his unit to look at the water intrusion on the unit ceiling. Mr. Wells inspects unit 2907 with Mr. Jackson and identifies the specific location on the roof associated with the stain. Mr. Wells and Mr. Jackson take measurements in the unit to assist in locating the affected area on the roof. So in December of 2018, ECLAT completes the roof work under bid. ECLAT also notices issues with the pitch pans above 2907, which apparently are the source of the problem. ECLAT removed or replaced abandoned pitch pans, and those things are the sealed encasement for the electrical lines protruding through the roof, or if you've got an abandoned antenna. So that was done specifically over Mr. Jackson's roof. In January 2019, ECLAT submitted their bid for payment, and they were paid about $6,700 to do the repair. And since then, ECLAT's not aware that 2907 has experienced any further water infiltration related to the roof. That's since 2018. As I mentioned, Mr. Jackson was remodeling his unit concurrently with some of these events, and he was supposed to have submitted a remodel agreement. He didn't do that. He was supposed to. He didn't do that. Interestingly, Mr. Jackson's contractor during the remodel cuts holes in the sheetrock and determines there's no mold, no issue with respect to mold within the unit. Now, Mr. Jackson sought approval for his reimbursement. We asked him to do that, and on December the 10th of 2018, Mr. Jackson sends an email to Mr. Kinahan, the community manager. Rob encloses the invoice for repairs to Suite 2907 at Preston Towers. Please let me know when I can pick up the check. It's for $27,000. Your Honor, we have a copy of the invoice. You see that it's not signed. You see that there are many line items here. DJ Oxford is an entity that Mr. Jackson owns, but you don't see anything with specificity or backup to this.
I apologize. I really can't read that. It's really small.
Let's see. Is it possible? Yeah, how can we enlarge it? Sure.
See if you can make your market down that go to the plus.
Right here.
See if there's it.
Your Honor, does that help?
Yeah.
Okay. So this is a bill. This is an invoice for $27,000. It's not signed by DRJ Oxford, a different entity that Mr. Jackson owns. And you can see it's got some pretty hefty line items. For example, resurfacing ceiling with level 5 finish. It's got painting for $200. And it's actually got line item number 8, value of non-use of condominium for 1 month utilizing alternative living quarters.
Okay, I can see it now.
Now that invoice has no attachments or supporting backup, such as estimates or receipt. Nothing whatsoever, just a bald-faced, unsigned invoice, which Mr. Jackson is asking for $27,000. In January 2019, the board asked Mr. Jackson to meet with him to address his invoice for reimbursement. And Mr. Jackson says he's there to resolve that invoice. And Preston Towers Corporate Counsel says to Mr. Jackson, we're not saying we're not going to pay this, but we really need the itemization of cost for repair to prove this up. That's not disputed. None of that's disputed. But Mr. Jackson refuses to provide the documentation to support that invoice. And then 2 months later, after the date of the invoice, Mr. Jackson obtains an estimate from a public adjuster, Jerry Bird, for the same repair that the DJ Oxford invoice had previously been submitted. And in this, and Mr. Bird is not there. He's not doing the repair. He's an estimator. He's coming in after the fact. And he's saying, all right, well, that repair that Mr. Jackson submitted the invoice for $27,000. His estimate now says $104,000 plus $31,000 for loss of use. And Mr. Jackson still does not provide the documentation for the DJ Oxford invoice before suit is filed in August of 2019. And in 2019, Mr. Jackson sues for over $100,000. Now, after the lawsuit was filed, Mr. Jackson did provide some documentation of canceled checks.
I think we're probably most of us here are homeowners, I would assume. And I mean, that's not unusual that you would have a contractor work for you and just provide an invoice. They may not have, I don't know if I've ever, I shouldn't say ever, but it's not unusual that they wouldn't have a signed invoice, and he provided you canceled checks at that point. It would seem like at that point, payment should be made or something should have been done.
Well, Your Honor, the problem is that you've got $33,000 worth of canceled checks, but the plaintiff is asking for $100,000.
Okay.
That's the crux of it.
All right, keep going.
Okay, so in between December of 2018 through August of 2020, there are no leaks reported, none. And in December of 2019, during that period of time, Mr. Jackson engages or commissions a report from LCA Environmental to perform a mold and mildew assessment. And what does the LCA folks find? Well, they say that there is no detection of mold growth, musty or mildew odors, and specifically no elevated moisture meter levels at all. So there's no detection of any kind of roof leaks or any kind of leaking that Mr. Jackson claims. This is in December 2019. So in August of 2020, Mr. Jackson submits a work order which stated that the water damage to the ceiling from the roof is noticeable inside the office room. And on that same day, August 20th, maintenance folks go out there and they note whatever deficiencies that may be out there. In December of that year, Mr. Kinahan writes to Mr. Jackson and he says, I was recently informed by the board of directors that on December 29th, you sent an email to them and mentioned that your ceiling may be currently leaking. I was not included in the email, and if you have not contacted the management office directly with the maintenance request, we are not aware of any active leaks on the 29th floor. If you're experiencing any water issues, please contact me immediately. We will need to come up and inspect the area as soon as possible. And on that same day, in response almost immediately, Mr. Jackson says, I did not report any leaks. That is a lie by the board of directors to harass me. So just before August, the rain data reflects there's only 1.45 inches in July, and there was really no measurable precipitation just before August the 6th, the day that Mr. Jackson reports his leaks. So what we now know is that what Mr. Jackson was looking at was a leak that he had repaired back in 2018, and that he had not properly painted or treated the stain so that now it was bleeding back over, and it wasn't a leak at all. It was just a situation where the stain was bleeding through the current paint, and nothing was, there was no roof leak at all. And this is the report that was prepared by Mr. Kessner, who's a professional engineer that went and looked at it and compared the two areas where he reported the leak we saw earlier in 2018 and this leak now in 2020, 2 years later.
Okay.
Now, in September of 2021, just last year, Mr. Jackson reported an HVAC issue. It was a ceiling leak. So Preston Towers community manager immediately responded to that issue, to determine what was the issue was, and found out that the leak, in fact, was another issue with the HVAC. Immediately, the pan was cleaned out, the lines were cleaned out, so that was taken care of. And then shortly thereafter, the contractor who was assigned to look at this HVAC came back in October and did a more detailed inspection. And he determined that there were 2 fan coils, 14 and 17 years old. And the units had a median life expectancy of 20 years, but based on his recommendation, Preston Tower approved the replacement at its cost. And they replaced the 2 existing fan coils with the new equipment and the associated work. The board also approved at its cost associated sheetrock replacement and painting. So Mr. Jackson's report of another HVAC leak is immediately addressed, no cost to him, everything is replaced. The cost of that to the Preston Tower is in excess of $13,000. So, Your Honor, Mr. Jackson has now got 2 separate components to his claim. First, what is owed for the 2018 repair he did that we were willing to try to pay before he filed suit for $100,000? And what is this damage that he's claiming today? Today, he's claiming damage because he says there's an ongoing leak. And because he has an ongoing leak, he needs to replace or gut essentially the entire unit. I'm talking about removal of sheetrock on most of the walls, taking down some of the laminate wall on the west side, replacing wood cabinets in the study. That's what he wants. It's not just we've addressed the $27,000 back in 2018, but today he's saying everything's got to be gutted. Everything's got to come down because there are continuing roof leakage. And that's based on his estimator, Mr. Bird, who says, well, I've taken a Tramex meter and I've gone to the walls and I see that there are elevated moisture readings. And therefore I conclude, and this is essentially what he's saying, I conclude that there's still a water leak because of those high moisture readings that I've taken on the walls and the ceiling. We're going to talk about those Tramex readings, Your Honor, and those are dispelled by the reports by the engineer and Hague Construction Consulting. Okay, what do the experts say about that situation, Your Honor? We're talking about today, something that was repaired back in 2018. Their conclusions are, and they inspected the unit and thoroughly, that there is no evidence that roof leaks in the unit reoccurred after September 2018. The existing stains along the unit's office and bedroom ceilings were the same locations and shapes as those that were shown from the 2018 that was repaired. The structural grade lightweight aggregate concrete does not require replacement. The custom cabinetry in the office reflected misalignment. There was no swelling, warping, or delamination of the cabinetry that could be reasonably attributed to roof leaks or elevated humidity. This is a big ticket item in Mr. Jackson's claim that somehow the wood cabinetry in his study has got to be replaced. That's not the case. There is no evidence of damage to the paneling on the west wall. That is paneling with some floating shelves due to water intrusion or variations of humidity.
Anything else? Oh, go ahead.
And there is no need to replace the drywall throughout the unit at all because there's no active water leak. There are no elevated moisture readings in the unit. Mr. Bird's elevated Tramex moisture readings were the result of improper use of the moisture detection equipment. He put it on wood and he was examining sheetrock. But more importantly, he was getting false monitors because he was putting those Tramex devices over metal tape and bent corners. And when you do that, you get a false positive. You don't get a true reading. The evidence is that our experts did do the Tramex reading and the readings were close to zero. Not only that, you would expect to see, if you had that type of moisture reading, you'd expect to see the deterioration of the walls or the sheetrock over time, and there's just no evidence of that. So there's no evidence of swelling, warping, or delamination of cabinets or the paneling. There's no visible evidence of recent or current water intrusion originating from the roof. But there is evidence of substandard workmanship and misalignment of the paneling on the west wall in the living area and the east wall of the master bedroom. And there's certainly no detectable odor related to mold or organic growth. That's what we have today here, Your Honor. Mr. Jackson's unit is fine, but he's claiming that he wants everything gutted for the tune of about $360,000.
Judge, once again, we're not here on damages. That's why you heard nothing from my experts, nothing before you on the amount of damage or the cost of damage. And what I think I'm hearing is an admission that the association has liability to pay for the damages to Mr. Jackson's unit. And the evidence in the summary judgment record is that there are damages.
Mr. Sutter, you have been going on for quite some time, so you need to finish up.
Okay. And Your Honor, to let you know what's going on today is that, in fact, the board is pursuing, and they started as early as before I guess in 2020, the board had already started the effort to try to find a way to get a new roof replacement. Nobody's saying that the roof needs to be replaced, doesn't need to be replaced. There's no evidence that it has to be replaced today. And so these efforts are ongoing as we speak, Your Honor. And those include contacting and locating contractors in order to be able to do the work, to get bids. They've also had to do some preliminary work to make sure that the antenna and the other areas that had leases on top of the roof were taken care of, and they're no longer there. So today, where we are is that there's funding. It took quite a while to get the lending done, the financing done through a lender, and the loan should be closing within this week, we hope. That's despite the fact that Mr. Jackson contacted the bank to try to discourage the bank from making the loan. We think that the loan's going to close this week. And the roof replacement will start hopefully around August or September 2022.
If I may, Judge, again, this argument has nothing to do with what's before the court. This is a trial of damages, and we haven't asked you to determine damages. What I believe I hear is that the association now admits that
Your
it
Honor,
should
can I,
pay
if I might
damages.
finish it?
Mr. Souter, you've been going on for a long time. I'm going to let Ms. LaBeouf
Right.
respond.
What is in the summary judgment record, and I'll be very succinct about this. This is a failed roof. The reports submitted by the defendants from 2018 and very early in January 2019 say this roof must be replaced and it is saturated. And Mr. Jackson's unit is right beneath that roof. And that's what's before you. There was a sealant, an epoxy sealant that was poured in 2017, and all 6 leaks that have been reported since then that caused damage to Mr. Jackson's unit specifically, as set out in the affidavit the defendants put in front of you of Mr. Kinahan, occurred after this sealant was applied. The association can say all day long, well, that invoice isn't good enough. No, that invoice isn't good enough. No, 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 no. But the question before you is, do they have a responsibility to pay for damages when they have failed to maintain or repair? And the answer is yes. And I'll briefly go back to Poozer. This reliance on Poozer, again, is misplaced. In that case, the court itself found that the appellee had a duty to maintain the common elements. And in that case, the issue before the court was a roof that was defective from the day the building was built. And the judge said, you know what? The HOA has a duty to maintain and repair, but it doesn't have a duty to go reconstruct the building. And so that case has no applicability here. And the association has told you, Judge, look to the property code, and the property code says you look at reasonableness when there are restrictive covenants, like can you put your condominium unit on Airbnb? That's a restrictive covenant. And so the evidence that's before you, what I believe I've just heard, is that the association agrees that it needs to pay for the damage, and we will come back and try what that damage is and what's going on in that unit and what has been affected by that unit. The 2 experts he cited to you just went in 2 weeks ago. So how they decided what has or has not happened since 2018, despite the affidavit of the defendant's own general manager, I don't know, but that's for another day. And so on the collateral estoppel piece, these same arguments regarding what the association has told Mr. Jackson, which is make a claim on your own insurance, it's not our problem, were heard in Judge Ginsburg's court, and that's the Tatiana Fearson case that was submitted to you with the summary judgment evidence. And the collateral estoppel that applies is only that narrow piece. When they fail to maintain the common elements and it damages a condo unit, are they liable for the damages? And Judge Ginsburg signed an order that said, yes, they are, just as to liability. We can fight all day long about attorney's fees and what are the costs and what should be paid. But when Mr. Jackson took this and gave it to the association, as you heard from Mr. Souter, the association said no, he had to file this lawsuit. That's what we're here on today, is just the liability piece for contract, and that there are attorney's fees owed under the property code that's been cited to you, for which there's no argument. Now, we have a no evidence motion on affirmative defenses, which we haven't gone into. Don't know if we have time for that today on one of your later hearings too, but I will stop talking and now defer.
Mr. Souter, did you want to respond to the
Yes, Your Honor.
last 2 points briefly?
Your Honor, the collateral estoppel rule does not apply to an interlocutory order. The order that is being referred to as interlocutory is not a final judgment. There is no reference to a reasoned decision on that order. And Your Honor, I'll cite you the Moyer versus Boyer case. It's a 1991 Texas Supreme Court that says basically that the district court's interlocutory partial summary judgment is not entitled to either res judicata or collateral estoppel effect.
Ms. LaBeouf, was this a final order or an interlocutory order?
Yes, because the parties settled thereafter, so it became final.
It's nonetheless interlocutory, Your Honor, and it can't be relied on for collateral estoppel. And Your Honor, I would try to emphasize that there is a reasonableness standard. There has to be what the condominium association does with maintenance. If tomorrow there is something that goes wrong that is affecting the common elements, and somebody happens to have something happen, this is not a strict liability. If the association attempts to make repair, it's not a guarantee or a warranty. They have to be given the latitude to try to find out how to do this, and that's what the boards are supposed to do. There has to be a reasonableness to this, and it was reasonable also to ask for Mr. Jackson to support his invoice with something to support it before he filed a lawsuit. And now that we're in this lawsuit asking for $100,000, there's no support for that. So there is a reasonable standard, and it is under 202.004. I'll point out that the Hoyt case, Your Honor, that we cited was in fact there was a duty, there was a special a fund that was set aside for the purpose of maintaining the canals. And in that court, the judge specifically applied 202.004A to the obligation to maintain the canals, the private canals, that there's some water entrance and egress to the docks there, and specifically applied it and said that 202.04A does apply, and there is a presumption of reasonableness, and there is no evidence that the board was acting arbitrary, capriciously, or discriminatorily in this case. Therefore, we're entitled to a presumption of reasonableness with respect to the actions of the board.
This case especially said what day? June 20?
May the 17th, Your Honor.
I don't think we're
it's not
especially set.
It's-
No.
It happens to be number one on the docket.
We have actually motions that will be heard, I think, in a week. One for a continuance and one to consolidate what's going on in the other case in Purdy's court, because when we get to the no evidence motion, you'll hear that here the association is telling you that Mr. Jackson has failed to mitigate his damages by pulling his condo unit off of listings for short-term rentals. And the reason he's doing that is the association has sued him in Judge Purdy's court for listing his condo unit for short-term rentals in an attempt to mitigate. And so we've asked that those be combined, just because, and it's just in stark contrast here today because of the no evidence motion of the inconsistent positions being taken by the association. And we've also added the individual directors because we've learned that there's been a denial of an insurance claim on the roof specifically because the board did nothing to maintain or repair. And so those things are pending and will be heard, not for today, Judge, but I don't know that we're going to go to trial.
Let me ask this, guys. What Mr. Souter, and I'm not trying to put you on the spot, but what is your position as to the continuance?
Your Honor, we oppose the continuance. If you recall back in December, I had proposed a date in August for the trial, and I'd already had a motion for entry of a docket scheduling order with prior counsel before Ms. LaBeouf. And I didn't get a chance to have that hearing. You asked when the trial was. I said that I was asking for August. You said that's too late. Ms. LaBeouf said that's too late. Ms. LaBeouf said, let's go earlier. You said May the 17th. And you said, we are going to trial on May the 17th. And I have been preparing and working toward May the 17th because that's the instructions you gave us, Your Honor.
But are there new parties that have been added
Yes.
to this lawsuit?
Yes, and we were just...
On March the 28th, the plaintiff added 20
Yeah.
former board and current board members to the lawsuit. We have a motion to strike that pleading that's also set for hearing in order so that we can address that issue and go to trial on May the 17th. It's just really fundamentally unfair when you say in your disclosure responses that there are no other parties that are going to be added. as up to even the day that you add 20 new parties for things like slander that allegedly happened 2 years ago, it's fundamentally unfair to bring 20 new defendants in this case. We need to go to trial on May the 17th, Your Honor.
Judge, if I may remind you, we were just here on a motion to compel, and I got over 1,000 pages of general ledger produced to me yesterday. Counsel before this court today represented to you that documents don't exist prior to, I believe, January of 2016. And we learned this weekend from the wife of a board member that there's a whole room full of documents with records going back 50 years is what she represented. And she's an accountant who sat and looked at the documents. We have huge document issues. We didn't get the reservation of rights in production either. We had to get that separately. And in seeing the reservation of rights, we see that their carrier says, you as a board have been negligent. I have to name them. So
Your
that's
Honor,
critical.
yeah.
And I didn't know about these issues when
Your
I
Honor.
first came into this case and asked for a May hearing or a May trial date. And I didn't know that we would still be playing footsie with documents on.
Your Honor, that's just completely unfair. We had a motion on this issue. I represented to you. We produced all the documents we had going that were specifically requested, and we produced those. We produced them back 2 or 3 weeks ago. We've not had any other documents that are going to be produced because we don't have those. We went through this on a motion to compel hearing, Your Honor. You heard all those issues, and I explained to you about the situation, Your Honor. We have produced everything that they've asked for. Yes, there are lots of documents out there for other things, but we're the specific documents that they have requested. We've been through that. We've looked for them. We've produced everything that we have. There are no other documents to produce. It's time to go to trial, Your Honor.
Yesterday, we got another big, because you told them they had to produce by today, and
No.
another big tranche of documents produced. And what Mr. Satter told you at the last hearing is I didn't even know we had a whole cloud full of documents.
No.
I'm going through them as fast as I can.
Your Honor, there was not any documents produced yesterday because we had already produced those 2 weeks ago. Those documents that have already been produced. We didn't produce anything yesterday.
Well, yesterday or Saturday, and I'm sorry.
No, it wasn't Saturday. It was 2 weeks ago.
Okay, I'm going to take this under advisement. And I'm going to consider this. I do urge you, this is the first time in this case, I will say, that I feel like we've really gotten to what I think the real issues in this case are. I feel, Ms. LaBeouf, and I haven't looked at it, so that suing 20 additional board members doesn't advance the ball here, but I can't prevent you from doing that. That to me definitely raises the hairs on the back of my neck, because that just seems like a tactic. I'm not saying it is. This is should be a relatively simple dispute. Was there roof leaks that weren't repaired properly by the association? And everything else is just to me, kind of fluff. And so I appreciate this motion, because I really, for the first time, feel like this is what the case should be about, is this dispute. Did they act reasonably or not? Was this, what is the history on this roof leak? And that's what the case should be about. And so getting into all of these other issues, I don't know that is super helpful, but I'll take this under advice. What'd you say?
When we try the negligence claim, Judge, where the arbitrary and capricious comes in is the negligence, and where we see arbitrary and capricious behavior, it is by these individual board members. But we'll talk about that at that next hearing. Do you want me to continue the hearing on the no evidence motion?
Go ahead and put it on our next. I know we have another setting next week on this. This is.
I know.
I'm just telling you, I don't like that tactic. If you really want to pursue it, you better have some very strong evidence, because it's.
And we looked long and hard at it, and I'm hearing you, but I think me and my firm, we don't play games. It's not just be ugly. But we'll address that, Judge, and I hear what you're saying.
Have you already submitted a notebook with all of the briefing on this case,
No, Your
No,
Honor.
Judge.
on this particular motion?
Oh, yes, Your Honor, we have.
And
I mean, what our
binder?
response, paper binder?
Yeah.
No, but I certainly can, Your Honor.
Okay, go ahead and submit a binder with everybody's briefing on it, both sides. To me, this is the central issue in the case that needs to be resolved. And so I do share both of I see both sides here. I see Ms. LaBeouf. I do absolutely think they have a responsibility to maintain the common areas. The question is have they raised the fact issue? Did they act reasonably to maintain the common areas? I think that's a close call. That's why I'm kind of struggling with this. So I want to take a deeper dive into it. And I will say this, anyway, that's all I'll say at this point. So give me some briefing on this. And then also on this issue involving the affirmative defenses too, go ahead and include that in the binder as well.
Thank you,
All right,
Judge.
guys.
And I'll include that property code in the cases too.
And then when is the hearing on the motion to strike their new petition?
Your Honor, this is the situation. On May the 6th, there's going to be a hearing on a few things. The first is a motion to consolidate the short-term rental case into this one. Another one is Mr. Jackson has filed a motion to appoint a receiver. He's asked that this court appoint a receiver over the association for the purpose of trying to
explain exactly this case in Purdy's court. Is you guys have sued him because he won't do a short-term rental? Is that right?
He's
No, they
violating
sued
the
him for
short-term.
doing-
He's violating the short-term rental policy, Your Honor. Their declarations require at least 30 days for rentals, and there's a good reason for that. But he's violating the short-term rental policy. So this notion about he has to do short-term because he can't do long-term, and that has nothing to do with this case. It's merely he cannot go forward and lease on a short-term basis. That's what it's about. And
They've made it
the
part
idea
of
is that they want to consolidate that into this case.
They've
So
made
who are
it
the
part of
actual, let me ask this, who are the actual counsel in this case? It's you, Mr. Sutter, you, Ms. LaBeouf, and who else?
Mr. Davis for ICI, and I think Mr. Ciotis is his co-counsel.
I want to take you guys into my chambers, which in this case is a breakout room. I want to talk to the attorneys real quick.
Thank you, Judge.
I'll include Mr. Godkin as well.
Yeah, Judge, this is Greg Godkin, Godkin. I'm also a counsel from Preston.
Okay, okay. I just have what your name is on the screen. So it's going to be Miss LaBeouf that goes to the breakout room. Let me see.
Your Honor, Rick Mosier, I'm helping Mr. Souter, so if you would let me win.
All right, so Mr. Ciotos, you're one of them, right? Okay, Mr. Greg G.
It shows me as Greg G. I guess I need to change that.
Yeah, you need to
my
change
last
that.
name. That's me. Yes, sir.
Who else? James Davis, you're an attorney on this case? Okay.
And then Rick Mosier, Your Honor.
And I don't want a bunch of attorneys from the same office. I just want lead counsel. Ms. LaBeouf.
Yes.
And
Mr. Souter.
yes, sir. Mr. Godkin represents the association with respect to this.
That's Greg G.
Yes, Your Honor.
I don't even know that he's made an appearance, but we can talk about that when we get there. All right.
Yeah.
Okay. I think I have everybody. If I don't.
Hey, Sophie Myers, are you on the call? Okay, I saw you unmute, so I'm assuming you can hear me. I'm just letting you know, I've got to leave in about 10 minutes. I've got to pick my son up from school. I had no idea this hearing would, take this long. So just heads up.
You guys hear me okay?
Yes,
All right,
Judge.
everybody on the Jackson case is excused. And we will deal now with the Mabanta case.
Bill me,
Thank you,
Judge.
Your Honor.
Your
Thank you,
Your
Your
Honor.
Honor. Appreciate your time.
Thank you, guys.
All
Your
right,
Honor,
Judge.
I'm sorry for jumping in. This is Harrison Oldham. I believe we're your last setting of the day.
Yes.
On the Penalt matter. I'm here on behalf of Penalt Projects, and unfortunately, I have got to go. My son's school closes at 6, and from the time it takes me to get out of my office and get down to see him.
I don't even see this. What case you hear on Bang, Texas versus Nusret?
Yes, sir.
Is your opposing counsel here?
Yes, Your Honor.
Do you mind
Miss
if we
Sophie Myers.
Do y'all mind if we move this, or how urgent is this? I don't know. Is this your motion or her motion?
This is, if you're
It's
asking
Ms.
me, it's my
Myers.
motion, but yeah.
No, on the Nusret case.
It's Miss Myers, Your Honor.
Ms. Myers, are you willing to move it? I can't hear you. Mr. Schwartz, what are you here for?
Mr. Schwartz is senior counsel at my office, and we're here on the Mabanta case.
Okay. Ms. Myers, we need to hear from you. Now she's Mr. Oldham, I have no idea. I have no problem with rescheduling this. I apologize.
Yeah, and I'm sorry too. It's just my wife's out of town and there's no one
No,
else.
I don't want your
to pick 'em
kids
up.
to be in danger, but we can't hear from Ms. Myers. Can you all hear? I can't hear.
No,
Cannot
sir.
hear, Your Honor.
And
Ms.
that is
LaBeouf, can you hear?
incredibly frustrating.
No, sir.
Why don't we get started on the Mabanta case, and if she can start, she can figure out her computer. What time do you have to pick up your kids, Mr. Oldham?
Yeah, his school closes at 6. The aftercare program closes
How
at
far
6.
away are you?
It's about 20 minutes. So
Yeah.
I've got, we're
Got it.
pretty tight.
Okay, she's okay with the continuance. So if you guys want to just redo this you want to do this on Monday, next Monday?
Just confirming, Your Honor. That's fine with me.
Do you have to pick up your kids again next Monday? Do you know? Is that
My wife will be she'll be back in town. She's just out for training for a few days. So
I get it.
I can really do it.
Okay. Can you just, let me just text Rhonda. Okay. Thank you, Ms. Myers. Thank you, Mr. Oldham. And you guys have a great rest of your day and good luck with picking up your kids. Thank you, Ms. Myers, for being professional and allowing him to do that. And we'll try to make sure we're hopefully not so late next week. Okay.
Absolutely. Thank you so much,
Thank you,
everyone.
guys.
Thank you. Bye.
Ms. LaBeouf, Mr. Herring, Tony, are you ready? For a long morning, long afternoon.
No, I'm sorry.
Yes, Judge.
All right.
Let's go on the record on DC 1818484 and Mabanta versus Act. Council, make your appearances.
Nicole LaBeouf for Dr. Shalane Mabanta.
Walt Herring here for the defendants, Your Honor.
All right, I've read the motions. Let's go ahead and hear argument.
Thank you. Judge, you're here on my motion for leave. I'm going to give you in as small a nutshell as I can our background. Dr. Mabanta worked for Dr. Echt in his practice. She signed an employment.
I know the facts. Why are you asking for amendment this late into the game? That's my concern.
Yes, so that first of all, we've asked to add defenses to limitations, and limitations was not even added by the defendants until August of this last August. And so it hasn't been just sitting around. And And so the two things that we'd like to add are discovery rule and fraudulent concealment. And that's not a surprise to anybody because we've alleged fraud from the very beginning. And we've been down here for 2 years fighting over trying to get documents. And, you know, we have a motion for sanctions, unlike any I've filed before, because we still don't have a complete set of the EOBs, the reports you gave us access to, we never got.
So all you're asking for is the 2 affirmative defenses to statute of limitations, nothing else.
Well, what we've done is go beyond the notice requirement, the notice pleading requirement, and add some details about the fraud, but we haven't added any other new claims.
No new defenses or causes of action other than that.
No, we just put the
Mr. Herring,
details
I've had a
in.
long day, Mr. Herring.
I know you have, Your Honor. I apologize.
I'm not fussing with you.
But the pleading deadline in this case was September 2019, 30-something months ago. And the reason we set pleading deadlines is so we can prepare.
But haven't you done new pleadings since then?
Well, no. In response to her second amendment, we had a pleading deadline that we were allowed to respond to her pleadings. And the court granted a motion for her to amend her pleading back in July of 2021. That was 2 years after the pleading deadline. And the court allowed the plaintiff then to plead a breach of fiduciary duty and negligence claims, which are new claims. So yes, we did file an amended answer to that to claim statute of limitations because those claims we believe are barred by the statute of limitations. So of course we did.
Your statute of limitation defense was only as to the new claims.
Well, honestly, there's a 3-month period where there was a breach of contract from 2013 to 2014, 3 months there and there that could have been barred by statute of limitations. But I didn't plead that because that's minimal. That's nothing. That would have been a ridiculous minimal amount to complain about. But these new claims, yes, they are more to complain about. So, and and it's not just a new defense. They've pled fraudulent concealment. That's not the same as fraud. They've said that we have somehow concealed this fraudulently, not that we have perpetrated some kind of fraud. And though that's not all they've done. Can I share the screen with you, Your Honor? Can I share my screen? Okay, here is there a red line of the new petition. And just scrolling through here, the red line.
I can't see whatever you're trying to share.
Oh, I'm sorry. I thought I was share screening with you.
Whatever you're doing isn't working. Sorry.
All right. Well, I won't try to figure it out while I'm doing. But let me just say that the red line of this petition, every single paragraph has changes to it. It's not just adding 2 new defenses to our claim for the fraudulent concealment and discovery rule claims. They have added a series of new factual allegations about new fraud claims that used to be just a promise we misrepresented. Now they're trying to claim we have promises we made that we didn't disclose. New fraud allegations in this new petition. They pledged a way to try to get around the estoppel claims or the promissory estoppel claims that we believe should have been a summary judgment. They're trying to plead around that. They're changing their defenses. They're changing their claims in subtle ways, all years after the pleading deadline. Also, several weeks after they announced ready for trial. We were ready to go to trial a month ago, and they said we were ready for trial. And then 2 weeks after they announced ready for trial, they've now said, oh, we want to amend our complaint. On top of that, Your Honor, Friday afternoon, after 5 o'clock this last Friday, I got an amended disclosure where they've added new disclosures, new claims in their disclosures, new facts in their disclosures, new damages in their disclosure, and added like 10 new witnesses in their disclosure. New witnesses.
Judge, you recall.
I mean, that's not what we're here about though today, right?
It's not. And you'll recall we both asked you for a June date. We were taking depositions of experts within a week of our last trial setting.
I'm not
And so-
saying that's not,
and
I'm
let
not
me-
saying that's wrong at all, Nicole.
And the reason was that we couldn't get the documents that we needed so that we could discover the extent of the fraud. And so we have added, the red line is in front of you, Judge, but when we look at the deposition of Dr. Mabanta more than a year ago, in early 2021, she was asked about fraudulent inducement. She was asked about the fraud committed by ACT. They came back in September of 2021 and deposed her again. She testified to the wise overpayment of the guarantee, the ongoing fraud that was being seen in the documents, the failure to pay her improperly resulting in a benefit to Dr. Eck. They deposed her on this. And so I haven't added new claims. I have brought the pleadings forward, disposing more despite no special exceptions because it's fraud. And I have pled with specificity as much as I could, much of it from the fact that we still don't have, their financial documents don't even match. They keep
So
reproducing.
this is what I'm going to do. I'm going to deny leave except to the extent that you have pled any defenses to their newly pled statute of limitations defense for breach of contract.
Okay.
So you can plead defenses to that if you still want to make that statute of limitations defense argument for breach of contract. You said it wasn't a big deal, but you added it. I'm going to allow her to do defenses to that if you just added that to an existing claim. Mr. Herring, do you not understand that?
I think I hear what you're saying. You're saying that if we want the statute of limitations to apply to the breach of contract claim, you will allow her to amend her petition to address that issue. Otherwise, not. Okay.
Otherwise, everything else is, all the rest of the motion for leave is denied.
Well,
Okay.
if he leaves limitations in there at all, and he did not specify it was for one claim or another, we have fraud, we have fraudulent concealment, negligence.
I don't think I'm
Okay.
required to plead specifically to which claim, but I understand the
Okay.
judge's ruling and I will abide by that.
I don't understand if the question is, if he leaves the limitations in there at all, may we
So
respond?
as I understand the history here is that there was an existing claims as a breach of contract. You later on, I gave you the
And fraud.
opportunity to add fraud and other breach of fiduciary duties.
Fraud
After
was
the-
there from the beginning.
Okay, fraud, I'm sorry, fraud and breach of fiduciary duty, fraud and breach of contract. And then I gave you the opportunity to add additional claims after the pleading deadline. So what I'm trying to distinguish between, I thought it was just two. So if you're alleging statute of limitations as to any, you added a statute of limitations defense, you said, Mr. Herring, to respond to their newly filed claims. They're not going to get to plead that in addition. They've already had their chance. But if you are adding statute of limitations defenses to their existing claims that were around before I allowed the amendment, then for those claims, I'm going to allow her to plead any defenses to statute of limitations because you just brought that up and those claims have been existing. Does that make sense, Mr. Herring?
I believe I understand what you're saying. Yes.
So are you going to continue to pursue your statute of limitations
I'm gonna have to
defenses?
go back and look at the pleadings again, Your Honor, to be honest with you.
Okay,
I don't know if I can make that snap decision here, but
that's
believe
perfectly
I understand
okay.
what you're
But you guys talk that out. Get me an order on this, okay?
All right,
Okay.
thank you. All right.
All right, thank you so much,
Thank
guys.
you,
Sorry
Laura.
for it was so late.